Prevention Act. Just a warning, I'm actually not going to talk at all about the part of the act, the foreclosure prevention part of the act. I'm just going to talk about the part dealing with renters, but it is a broader act than just one that focused on tenants, and so you can take a look at the language of the statute. At the end, I link to the court's website, and the statute can be found there. So next slide. Okay, so the law has the basic structure of the law is 2 periods of time. The first one, which is the time period we're in, is a 60-day pause. That 60-day pause ends after February 26th. And the second, in the second period of time, which goes until May 1st, courts reopen, but if a tenant files a declaration, the case will stop until after May 1st. The purpose, as I understand it, of the first 60-day pause, the time period we're in right now, is to make sure that tenants, especially tenants in pending cases, know about these declarations and are given the opportunity to fill them out if the declaration makes sense based on their own personal circumstances. There's one exception to both of these time periods and pauses, which are nuisance cases. And I'm going to be discussing this exception later in the training. But the thing to understand as I go through this is that these pauses, these stays of cases, when tenants file declarations are the way things will be until May 1st, unless there's an allegation of nuisance. Those cases are moving forward and will continue to move forward. Next slide. So as I said, there are 2 time frames, a 60-day period, and then the one that starts after February 26th. Right now, no cases can be filed, no cases can move forward, no evictions can happen. And one of the things that the courts are required to do by the statute is to notify every tenant in a pending case that these declarations exist and give them an opportunity to fill them out and return them to the court. We've been told that about 400,000 declarations were sent to tenants in pending cases. It was an overbroad mailing. We've heard from clients of ours, I've heard stories about how people received declarations whose cases closed years ago. The other thing I will say is that I've seen the letter that was attached to the declaration. It's a little complicated. It uses legalese, and we understand that tenants may be confused by what the court is trying to communicate. Certainly, it's been our experience at the Legal Aid Society when we think about the notifications that go to our clients, is that the language, just figuring out what language to use to clearly communicate the information we're trying to communicate is important. And not all government forms pay attention to that. And having looked at the court's form, I can understand why tenants may be confused. Next slide. So after February 26th, if a tenant signs the declaration and returns it to the court, the case can't move forward until after May 1st. Once a tenant signs a declaration, that's it. The case doesn't move forward. there's no way in the statute for anyone, including the landlord, to challenge the information that's in the declaration. And also, many of you may know about a law that was passed in last May called the Tenant Safe Harbor Act, which says that if tenants have a financial hardship due to COVID, landlords can't get a possessory judgment for the money that is owed during this time period. Which means that the money is still owed. The landlord can seek a monetary judgment, but the tenant can't be evicted for that money. The eviction law makes clear that if a tenant files a declaration, there is that creates a rebuttable presumption that the tenant qualifies under the tenant safe harbor defense, and the landlord would have to bring forth evidence that that's not the case in order to challenge that. Next slide. The statute has a separate provision in cases where there's already been a warrant issued, and the language here is interesting. And I don't know that a court has looked at it and interpreted it, but the way I read it is that if a warrant has been previously issued, that warrant has to now contain language that this law was complied with. Which, you know, if a warrant was previously issued, there's no reason why it would mention this law or that the provisions were complied with. It didn't exist at the time. It seems to suggest that courts either need to reissue already issued warrants or hold off on warrants. You can't execute on a warrant until after May 1st. And I don't know how the court is going to interact with this provision, but it's something to keep an eye on. Next slide. There's also a separate provision in the statute for cases where there are default judgments. Courts can't issue a default judgment without first holding a hearing and after the landlord has served the tenant with a motion. Before this law, this is especially important in non-payment cases. When someone is served with a non-payment petition, the only way that case gets into court and gets on a court's calendar is if the tenant answers the petition. If the tenant doesn't answer the petition, the case is defaulted, and everything after that is ministerial. The landlord requests a default judgment, the judge signs off on it, doesn't have to hold a hearing about what happened. It goes to get a warrant issued and then goes to a marshal. And we understand that from folks who are part of this training, from our own colleagues, that when the courts went virtual, tenants found it immensely difficult to actually answer their petitions. Tenants would go and wait online. I see a question, what's a default judgment? A default judgment happens if either a tenant misses a court date and then the landlord wins, or in the case where you're with a non-payment case, where a tenant's been served with a non-payment case, if the tenant doesn't answer the petition, doesn't put an answer in, the case is defaulted and the landlord wins. As I said, before COVID, what would happen is the tenants get the non-payment petition and they go to court and they stand online, oftentimes for a long time, and they get up to the clerk's window and they say, I got this piece of paper, what do I do? And the clerks would work with the tenant to help them fill out the answer. They would then get a court date. But if the tenant doesn't answer the petition, the case gets defaulted, the landlord wins, and even if the tenant has a really good defense to this case, you can't bring it up because the tenant has already lost. The way the tenant would address that is go to court and file an order to show cause. But all of those activities assume that one can get into the courthouse and talk to a clerk, which since we've gone virtual hasn't happened. A lot of tenants who tried to answer petitions, as I said, would wait online. And because there are so few people actually in the court these days, they were turned away, or they would call the number that the courts have set up. And that, my understanding is that it is hard to get a hold of anyone. Most people call the number, it rings and rings and rings, and they never get through. And so this law, the legislators, I think, have heard from a lot of people about this problem. And so they set up a separate provision in this law to require courts to have a hearing so that people who didn't have an opportunity to get into court can have that the landlord can make a motion, and then everyone can get in front of the court, and the landlord will make their case and the tenant will make their case. But tenants don't necessarily lose just because they can't work in a virtual world. If a default judgment has already been issued, the law allows the court to simply lift the default and let the case go forward on its merits, where everybody talks about the issues in the case. Next slide. The law has a set of provisions for cases that have not yet been filed once after February 26th. In those cases, landlords have to serve a copy of the tenant declaration with the predicate notice. Every case that goes to housing court, before it ends up in housing court, the landlord has to serve the tenant, has to give the tenant a notice warning them that the case is about to begin. In non-payment cases, that's called a rent demand. But in cases that don't involve rent, it's usually referred to as a notice of termination. And so when the landlord sends out new rent demands, new notices of termination, they have to include the declaration as part of that. If the tenant returns the declaration, the landlord cannot file the case until after May 1st. If the tenant does not return the declaration, the landlord can file a new case and then must submit an affidavit that the declaration was served and not returned. On the first court date, the court will ask the tenant whether they received the declaration. If the tenant didn't receive the declaration, the tenant will get 10 days to decide whether or not to sign it. Next slide. So everything I have just said about how it works for people who are about to be in housing court, people who are already in housing court, it's a different story if the allegation against the tenant is nuisance. So nuisance, just so folks here understand, nuisance is a term that we use. It's actually found in the rent stabilization law. And so obviously that's the standard. But it can, you can have behavior that's considered a nuisance in other types of housing. But everyone always refers back to the code. And because of that, in the statute, they decided to not call it a nuisance, but actually put in what is the type of behavior they were expecting this exception to refer to. And so the language is here. It's persistently and unreasonably engaging in behavior that substantially infringes on the use and enjoyment of other tenants or occupants, or causes a substantial safety hazard to others. So I think what I would pull out of here as being important language is persistently, the behavior needs to be ongoing. We're not talking about one incident, but something that happens on multiple occasions. It also has to be behavior that neighbors are complaining about, that makes life difficult for people's neighbors, or that causes substantial safety hazard to others. So, you know, we all live in, well, we live in New York City, and many of us live in multiple dwelling units. We live in apartment buildings with neighbors. And there's always a negotiation between how we live together. There are certain, you know, I've often seen cases involving noise, for example, where someone complains that the children above are running around. And to some extent, there's or that your neighbor above plays the television or plays music. And there's always this understanding that, you know, people have to be thoughtful about their neighbors, but also we have to live our lives, and not every building is soundproofed, unfortunately. And so there's understandings of, when it comes to the noise situation, you know, what's reasonable, what's unreasonable. Someone playing music at 4 o'clock in the afternoon is one thing. Someone playing music at 4 o'clock in the morning is completely another situation. And I think most people would agree loud music at 4 a.m. in the morning is probably behavior that persistently and unreasonably infringes on the use and enjoyment of other tenants. But we have to be, you know, we also have to be thoughtful and careful, because we have seen these type of cases show up in buildings that are gentrifying against long-term tenants whose neighbors never had a problem with their behavior, and new tenants move in, and landlords suddenly you get complaints. One of our clients, we have one case now where a tenant who's a smoker and has always smoked in their apartment building is now involved with a nuisance case. New neighbors moved in, and the new neighbors say this is unreasonable, and this is you know, this is bothering me. And so I mean, when we see these nuisance cases, I think people should keep an eye out for cases that actually buy into racist ideas in our society, systemic racism, and also that we should keep in mind that sometimes people caught up in these cases are people who are struggling with mental illnesses and who may need services in order to modify some of the behavior. The other thing I will say is, because these are the cases that are moving forward, and because the people involved in these cases sometimes are the most vulnerable or fragile people in our communities, that the legal services programs that do right to counsel work are trying to represent each and every one of the tenants in these cases, so they aren't so that they aren't unprotected. Anyway, next slide. So I just wanted to go through what the declaration is, and I took this language straight from the statute. I am the tenant, lawful occupant, person responsible for paying rent, use and occupancy, or any other financial obligation under a lease or tenancy agreement. I think they wanted to make sure that tenants who didn't have leases, especially outside of New York, many tenants are month-to-month tenants, and so there was an attempt to make sure that this covered tenants in all sorts of situations. So in the tenant declaration, there's option A or option B. You can sign one or the other or both. The option A has to do with people who've been suffering, who cannot pay rent because of because they have either suffered a decrease in income or an increase of costs, or something about the emergency. The COVID emergency has caused them not to be able to pay rent, maybe get a new job. Maybe they were unemployed before and now they can't find a job because unemployment is through the roof because of COVID. So, so first you have to say, I'm experiencing a financial hardship and I'm unable to pay my rent or other financial obligation under the lease in full, or obtain alternative suitable permanent housing because of one or more of the following. The thing I would like to note about this is when you check A, you're checking one of the next 5 things is true. You don't have to check which one is true, but just one of them is true. Next slide. So here are the 5 options. Significant loss of household income during the pandemic. Note that it says household income. It's my reading that if you have a client or you're working with a tenant where the reason they were able to pay their rent beforehand was they're on a fixed income and they had a roommate and their roommate was paying half the rent. And then their roommate lost their job and maybe moved home to be with family. That would be a significant loss of household income for the household. I mean, there was a roommate, they were together, they were putting their money together to be able to pay the rent, and they can't anymore. Increase in necessary out-of-pocket expenses related to performing essential work or related to health impact during the COVID pandemic. Childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member during the COVID pandemic have negatively affected my ability or the ability of someone in my household to obtain meaningful employment or earn income, or have increased my necessary out-of-pocket costs. I mean, we all know people who have had incredible difficulty working outside the home because their children have been going to school online. And, you know, there was at least one case that I saw in Albany, New York, in which someone left their job. They quit their job back in the spring because their young children, elementary age children, school was closed. And if they weren't home with their children, no one would be home with their children. And the judge found that that wasn't a COVID-related financial hardship because the person had voluntarily quit their job. I think most people would acknowledge that, you know, choosing between neglecting your children and having child welfare come and take them away because you've left small children alone at home, and quitting your job, most parents, I think all parents would choose the safety of their children. And so this provision was, I think, specifically in response to cases like that. Moving expenses and difficulty I have securing alternative housing make it a hardship for me to relocate to another residence during the COVID pandemic. And lastly, this is sort of a catch-all in case the drafters of this legislation left something obvious out. Other circumstances related to the COVID pandemic have negatively affected my ability to obtain meaningful employment or earn income, or have significantly reduced my household income, or significantly increased my expenses. So that's the option A. And option B is supposed to cover people who, that's the next slide, sorry. Oh, sorry, if you've signed option A, You also have to agree to this following sentence, which is basically that if you've lost income or if you've had increased expenses, the government programs that you've applied to have not completely covered your costs. Look, had the pandemic unemployment benefits that people got during the spring continued on, it's entirely possible that people would have had a difficulty signing this declaration. Sadly, though, people lost those additional unemployment benefits at the end of July, in August, and since that time, for most people, the benefits that they have gotten on regular unemployment benefits, any other sort of benefits that people have received, just haven't managed to keep up with the loss of income and the increased costs. So the next slide is the second option that people can sign. And this is for people who are actually haven't lost income and have been paying rent. This says that vacating the premises and moving into a new permanent housing would pose a significant health risk because I or more one of my members of my household have increased risk for severe illness or death from COVID due to being over the age of 65 and having a disability or having an underlying medical condition which may include but is not limited to being immunocompromised. Some of this language comes from the CDC's moratorium. People may know that the federal government has a moratorium, in my opinion, not as strong a moratorium as we have in New York. The reason the federal government's moratorium comes through the CDC is that there's a shared understanding that evictions during this time of COVID are very dangerous and make it much more difficult for us to get the virus under control. There was a study done by some public health academics that looked at jurisdictions that lifted their eviction moratoriums after the spring. And what they found was there was an increased number of people getting sick and an increased number of people dying in jurisdictions that lifted their eviction moratorium. And that in places that kept their eviction moratorium, lives were saved. The reason the legislature enacted this law was to save lives. It's a recognition that we're in the midst of a terrible epidemic and that at a certain point, we need to keep people housed so that we can address the virus, get people vaccinated, and hopefully get back to our normal lives. Next slide. So this is part of the declaration. Tenants need to understand that just because they signed the declaration doesn't mean that they can breach their lease in other ways. If your lease says that, I don't know, for example, you can't have a washing machine in your apartment, signing the declaration doesn't, give you leave to get a washing machine in your apartment. Your lease is still your lease. This just addresses the two things that are explicitly laid out in the statute. And it doesn't deal with the issue of late fees that you may have to pay, and it doesn't wipe away your rent. This declaration doesn't cancel rent. So the declaration lays this out. I just saw a question that is this form on the internet. We will get to that, where you can find it. I think in the last slide, it's in multiple places on the internet. Um, Next slide. And, you know, the form the form tells tenants that you're signing and submitting this form under penalty of law. We often say penalty of perjury legally, but some legislators were concerned that no one knows what that means, and that's probably accurate. So they wanted to spell it out, which means that it's against the law to make a statement on this form that you know to be false. And that's just one of the definitions of perjury. So if you're working with someone and they say, no, I've lost no income, no, I've had no increased expenses, no, I haven't cared for a family member, nobody, you know, no one in my house, like no one in my household is at risk of, no one in my household is at risk of COVID. Yeah, I have a huge bank account, I could easily move. They really shouldn't be signing this form. That's one of the reasons why we should be working with people to go through the documents so they know what's in it and they know that what they're signing is true. And we should be making sure that no one is signing anything that they know to be false. Next slide. So here are the links. So I'm just going to tell you what these links are. So the first one is the link to the court website. The thing that's important about the court websites, the link I have on the court's website, they have the declaration. They also have 19 separate translations of the form in a slew of different languages. So to the extent that you're working with someone who doesn't speak English or who struggles in English, there's probably a form that the court has already created in the language of the person you're working with. It's I'm not going to go through all the languages, but you know, it's 19 different translations, which I think is pretty significant. There are two forms that allow people to fill them out online, and through that online form, the form will be sent both to the court and to the person's landlord. I also have legal aid's information on here because I work for legal aid, and so to the extent it's helpful, we have the email addresses for every one of the New York City courthouses on where to send the forms. I understand that people who are in pending cases are signing these forms, but also people who don't have pending cases are signing these forms because they just want to make sure that that they get their form in. The case with pending cases, tenants can send the form in. If they get it from the court, it will have their index number in. They send it in, the court will put it in their file. For tenants who don't have cases that have started, there's no index number. We are told by the courts that they are keeping Excel spreadsheets so that if a case gets filed, they can look and see if they've received a form from the tenant and then attach the form to the tenant's file. I have no idea how that's going, but that is what we are being told is what the court is doing. And so I think I can open it for questions. I haven't actually been paying a hell of a lot of attention to the chat, so I'm going to try to take a look at the questions, but I don't know if people, I don't know, Jessica, how you would like to, I see a message about talking about foreclosure. I'm not a foreclosure expert. I don't do any work on foreclosure. I really can't speak to foreclosure. The slides are available. They're not on the slides aren't available on my website, but I understand they're available on Housing Court Answers website. How does this work for roommates? My roommate stopped paying because he said he hasn't even lost his job. Well, that is a problem. If both you and your roommate, have kept your jobs and none of these categories in the declaration, are true, you can't sign the declaration and the case is going to go forward. And you might want to show the declaration to your roommate and explain that actually cases can move forward if the declaration isn't true, and maybe your roommate will respond to seeing it in writing. I'm sorry, I see a question from Andrew, and I'm not sure I understand it. Andrew, can you unmute and ask your question?
So I allowed you to unmute if you want to. Maybe not.
Andrew? Okay. Does this declaration apply to ejectment actions in Supreme Court? Yes, that is my reading of the statute. It's about any case that involving a tenant where at the end of the case, the tenant is evicted. It doesn't, however, apply to civil court actions for money judgments because the end of that case is not an eviction. Have these declarations already been mailed to people? The declarations have been mailed to anyone with a pending, a case that was already pending in court. But as I said, we have some concerns that people have gotten these letters from the court and they've been somewhat confusing. So to the extent you're talking to someone who has a court case, you might explore with them whether or not they received it and then explain to them what it is. Because it might break down some of the concerns folks have. And I get it, like getting letters from the court is scary. And so, having someone walk through what they received would probably be really, really helpful for tenants. So if a tenant doesn't have a case yet, but would like to submit a declaration, do they send it to their landlord, the court, or both? I would recommend both. I would also recommend for any tenant who is filing the declaration, take a picture of the declaration, or if tenants have the ability, make a copy, but I think probably taking a picture of the declaration is the easiest for people with technology they have access to, so that they have proof that they filled out the declaration if asked. I have a client tenant that has completed and mailed the declaration. Will they receive a response back in the mail of the pending case being on hold till May? I don't think they will. So they should continue. I don't think the court is, when the court receives the declaration, I don't think the court is then reaching back out to the tenant saying, we received it. I suppose it's possible they're putting in new court dates, but I just don't know. If I were the tenant, I would continue to look online You can look online, and the legal aid website explains how. You can look online to see what's going on with the case. Yeah, so if a tenant doesn't have a pending case, would they submit the declaration directly to the landlord? Getting a hold of a landlord's address can be difficult. Yeah, I agree. The one of the two links I gave you, just the evictionfreenewyork.org one, does have a way to get a hold of landlord addresses. In cases in which the landlord is seeking to file a case, there's a new case, and the landlord sends out a rent demand and then attaches the declaration. The law does require them to tell the tenant how to return that declaration, what's the best way. This form does work for NYCHA tenants. Yeah, NYCHA tenants get it. Do tenants have to send the form back to the courts? I've heard information about tenants giving this form to their landlord. So I think, for my advice on this is that if a tenant has a case, they've already been sued in housing court and they're already in court with their landlords, the best thing they can do is send the form to the courts. Because there's nothing in the law that requires a landlord to inform the court that they received the declaration for already ongoing cases. You know, I think the safest thing is probably for the tenant to send it to both the landlord and the court. These are pending cases. In cases that haven't started yet, I think it's important for the tenant to give it to the landlord so the landlord knows not to start a case. I see a question from Elizabeth Malone. Is there an official statement from the state that says there's no moratorium on rents? Elizabeth, would you unmute? I'm not sure I understand that question. Okay, well, if feel free, Elizabeth, to yeah. Oh, Elizabeth.
And at least one of the insurrectionists may have intended to steal information.
Okay. Does the tenant have to prove their hardship in court after filing the declaration? No. Andrew's question was about Andrew. I'm sorry. I still don't understand your question. I'm going to ask you to ask it.
Infiltrated the crowd, or at least coordinated with
Andrew. In regards to late fees, are they still on hold due to the moratorium? Late fees have never been on hold due to the moratorium. There have at times been executive orders that have put the late fees on hold. I'm actually not sure if that moratorium is still in effect. Sorry, not moratorium. If that executive order is still in effect, but that's what would govern late fees, not this law. Are all legal agencies assisting tenants in filling out the affidavit of hardship declaration? Absolutely, yes. You know, all tenants should be told they can call 311 and ask for the tenant helpline. All of the right to counsel, all of the legal services programs that have money from the city for right to counsel spend a day. It's easy to divide up the week into days. Spend a day running hotlines. That means every day a different organization staffs the hotline in order to be able to talk to tenants about their cases. And one of the things we're absolutely doing is going through the hardship declaration with tenants and talking about whether it makes sense to sign it and giving them advice about how to submit it. Is there a number that renters can call to get the HD due to lack of internet? Maya, what's the the hardship declaration due to lack of internet? I mean, if someone doesn't have the internet and if someone doesn't have internet and they don't have any friends who can access the internet for them, there are tenants' rights groups who may be able to mail it to them. If they have a pending case, they should have received it from the courts. They can call 311 and ask to speak to the tenant helpline, and maybe one of the legal services programs can help them get it. But I think that's one way I would address lack of internet. If the tenant is undocumented, income may not be on record. Should the tenant still complete the form? Yes. You don't have to prove anything here. If the person is undocumented, even if they worked off the books and lost it, they still come under this law. Sorry, I'm going through these as how about Mitchell-Loma tenants? Can they also fill out the form? Absolutely, yes. I would suggest the hardship declaration be sent certified mail to the landlord. I always think it's a good idea to have proof of anything that you mail out or send to anyone, and certified mailing is a great idea. If they don't have to prove their hardship, what's to prevent tenants from simply checking off a box without it being true? I guess the answer would be, they could theoretically end up in a case with a district attorney because they've lied on an official form. But I'll note that I often see statements signed under penalty of perjury in court from both sides, from both tenants and landlords, that don't end up being true. I mean, this bill doesn't stop rent from being owed. And eventually people are going to have to pay off rent. Certainly, if someone is a working person and has decided not to pay rent, and their landlord knows that, I would expect their landlord to sue them in small claims court, and for their wages to be garnished and their bank accounts to be attached. So I think tenants need to be thoughtful about the risks of just deciding not to pay rent when they can. I will tell you that it is my experience during this crisis, speaking about legal aid's clients, that most of our clients are killing themselves to pay rent, and they are going without buying food and other necessities in order to pay rent, because keeping a roof over their head is so important. We've heard of people who are borrowing money from every family member they can think of, people who are putting their rent on credit cards. In my experience, people who can't afford to pay rent are paying rent. More people who can't afford to pay rent can't pay rent than people who people are choosing not to pay rent when they can. If the landlord gave you a tenant termination notice to vacate the apartment, and the tenant is current on rent but can't vacate the apartment for reasonable financial reasons, not having money to move, I mean, I would look at the part of the declaration that says I can't afford to move and see if that rings true, and if so, that may be a reason to sign the declaration. How would the governing agency determine if the applicant is truly experienced a hardship? There is no governing agency. There is no governing agency. If a tenant has an assigned GAL, would that declaration have been sent to the GAL or a tenant? That is a really excellent question. I think it should have been sent to the GAL. I would hope it would be sent to both, but I don't know the answer to that question. Upstairs neighbor is making noise. The landlord says I can't do anything to the upstairs neighbor unless the tenant below is willing to go to court and write a complaint when I do a holdover. This puts the tenant below in danger. Is it true the court requires the tenant below to show up to court and write letters? I mean, so if a neighbor is creating a nuisance, the landlord and the tenant, the landlord wants to file a case against someone who's creating problems for the other people in the building. The landlord is going to have to prove their claims. And I guess the question is, how do they do that? And when it may be that the only way they can do it is to have the people who are being bothered come into court and testify. But I don't know, it's going to be a very, it's going to be a question that can only be answered by the specific circumstances of the case. Does 311 have capacity to send physical forms? My guess is no. But that's part of the reason why there are a lot of different organizations out there that are working with tenants that do have that capacity to send physical forms. And that's not just the legal services providers, but it also is community groups, tenant-based groups. There are a lot of people around the city who want to help tenants who need them, who can help mail out the physical forms. Is it improper for a landlord to send a notice to vacate letter to a tenant if the lease is still active? If so, would the landlord have to wait till the lease is over? Assuming the notice, that is a hard question. I think it depends on what the letter, the notice to vacate is. Now, for example, if a tenant is unregulated, the landlord does not have to renew the lease at the end of the lease term. But the law does require them to give tenants notice that they're not going to renew the lease. So if a tenant has lived there for up to a year, a landlord has to give 30 days notice, up to 2 years, 60 days notice, up to 3 years, 90 days notice. So in that case, the landlord is, if you're dealing with a tenant who's lived in the apartment 3 years, the landlord is actually required to send a notice to vacate letter while the lease is still active, in order to give the tenant enough time to understand whether or not the lease is being renewed and what their options are. With the disparity in inflated rent and so many landlords going into foreclosure, wouldn't it be good to have universal rent structured law? You know, I support universal rent stabilization. I would love to see it. I don't think it's going to happen, but I would encourage everyone to participate in some of the housing movement that's out there that is trying to get universal rent control. Maybe people dealing with noise complaints should be seeking mediations. New York Peace Institute provides mediation services. That's a really good point. Would video or audio recordings of nuisance be a way of proving nuisance by neighbors? It really depends on what the circumstances of the case are. For some cases, yes. For some cases, no. Sue the landlord in HP for harassment if they refuse to evict noisy neighbors. So I've gotten to the end of the questions and I'm almost at the end of the time. I do want to say one more thing. I know we're about to be over. The federal government passed, as part of the COVID relief package that was enacted at the end of December, a program of rent relief that we will soon be seeing in New York State. New York State in total received, which includes some money that went directly to localities, received $1.3 billion. And they are in the midst of coming up with a rental assistance program that will hopefully be rolled out in the next month or two. One of the things I think the idea behind this moratorium is to give time for that federal money to start coming out and to start paying off people's arrears. $1.3 billion is probably not enough money. Right now, Congress is talking about sending another $19 billion to states. The first tranche of money was 25 billion. The second will be, we don't get the 25 billion, we got 1.3. The second tranche of money will be 19 billion. Hopefully we're soon going to start being able to address people's arrears and clearing rent debt, which I think is the most important thing. People should keep an eye out for that. I assume as soon as that program is up and running, there will be multiple trainings on how to get people access to that relief. I think that's what I have to say. We think it's going to be through HRA, but I don't actually have, we're still learning the details. It's still being designed as we speak. Anyway, Jessica, I think we're out of time. Yeah,
We are. Thank you so much, Ellen. That was very useful and helpful. Thank you everyone for joining us. Yeah, thank you, Ellen, for your time.
you got it.
Everything's on the website. We have some more trainings coming up in the next couple of weeks. So everyone have a lovely day.
I have a question. Can someone answer?
Yes, sure.
Thank you. The money that's coming up now, is that going to be a loan or is it going
No.
to? It'll be just,
It's not a loan. You can't ask for repayment. It's not going to be a one-shot deal. And just if you're interested, there was a bill introduced yesterday on how to spend that money. And one of the things that bill does is say during COVID, you can't ask for repayments of one-shot deals. So
you can't ask.
cannot ask people to repay one-shot deals during this time period. Anyone who gets a one-shot deal, during this time period can't be asked to repay.
Okay. Oh,
So
that's good news.
that would be great if we get that bill passed. So keep an eye on it.
And who's doing that bill?
It was Senator Kavanaugh and Assembly Member Simbrowitz.
Okay.
It's called COVID Emergency Rent Assistance Program Bill, I think, CRAP.
Okay.
But does that bill include like is it only covered during the pandemic, or is this assistance that is provided during the pandemic?
So this is a bill to spend the federal money, and the federal money does require the arrears. The federal money only allows 12 months worth of arrears. So I think it's going to be hard to spend the money on arrears prior to COVID. It's gonna, we're figuring this out as we move forward. The other thing I should say about the federal money, in case people are interested, is that the state will not be able to discriminate against people based on immigration status. So it will be open to everyone, no matter what their immigration status is.
Helen,
All right. Yeah.
I have a client that is in arrears due to her Section 8 recertification paperwork that's constantly being misplaced. Can she fill out the hardship declaration form?
She